favor? Aye. Opposed? That's approved.
We're looking at this to see if any of these rule changes have been made inappropriately, rule changes that would perhaps abridge one's constitutional rights, and I do believe we found a couple things.
Your Honor, will these letters be posted in the minutes of the meeting in the future? Because
I'm sorry, I think the rules are that although we allow members of the public, there can be no comment. Thank you.
I believe that's at the discretion of the chair, Your Honor.
The chair is
Robert's Rules of Order.
The chair is going to continue with that procedure.
I have seen and been a part of numerous efforts to strip me and my daughters of their constitutional rights, and I've seen firsthand the extensive corruption of the Connecticut court system, particularly in Stamford, and I'm extremely concerned about the legal future of Connecticut and the runaway corruption in the Connecticut court system. And I think the only way to successfully try to address this is for citizens to band together and to share their experiences and to get involved with any types of legal actions as a group that might be helpful in ameliorating the situation.
First order of business from Judge Holzberg, A2, to amend Rule 2.2.
What we are putting together is the case for how the Judiciary Legislative Committee has worked with the Judiciary Administrative Committees of this state, which include the Family Commission, the Advisory Committee for Appellate Rules, and the Rules Committee, to engage in the art of self-empowerment.
Pretty upset about what the courts are doing with our children.
Yeah.
They're violating our children's civil rights and
What do you have to say
father's
about
civil rights.
what about Linda Monroe's hearing today? What do you have to say about that?
Talk to him about it.
Oh yeah, what do you want to say about Linda Monroe?
She refused to release various documents to Mike Nowacki, and also
Judge Monroe said that she publicly at the Fatherhood Task Force that she would answer all our questions. She blocks our emails, doesn't speak to anyone, and now we're here to show that we're not giving up on our kids.
Okay. How are constitutional rights overridden day in and day out in the divorce courts of Connecticut?
I'm in a situation right now where there's been an attempt to install a guardian ad litem in my case, which involves the custody of my children. I'm currently being challenged by an abusive mother who seeks to now have full custody of my children after we've split custody for, since the beginning of 2005, so over 6 years now. The guardian ad litem, Jill Plancher, has numerous conflicts of interest with my former wife's attorney, Gary Cohen. I've discovered these, they're in front of the court, but the effort made to install this guardian, where then she can make whatever recommendation she wishes, free of any type of legal interference or with full immunity from any type of prosecution, no matter what she does, good, bad, indifferent, or illegal.
But as a reminder, if your remarks are going to exceed 5 minutes, I would ask that you submit any additional comments in writing. The Rules Committee will then consider your additional comments, the written comments, as we consider any revisions to the proposed rules.
Clearly, she was brought in to completely alter the custody of my children and to strip me and my minor girls, and not only strip, but rape us of our constitutional and legal rights.
One of the big problems with the GAL is, and the AMC, is that the court has not established guidelines as to when their tenure, so to speak, is terminated. in my case, we settled custody in 2008, and our GAL and AMC were still on our case as of 2010, billing us regularly. I don't know what for. They weren't major custody issues, but we could not get them on. We still have them listed on our
But they
case.
can instigate their own issues and,
Yep.
and basically make their own paycheck.
I do believe they create issues just to be paid.
The transparency of the judiciary is one of the foundations of our democracy, just as it is important, just as it is impossible to overstate the importance of providing justice. It is essential to uphold the principle of seeing the public. Transparency allows the public to see and understand the actions that courts take in their name, and it provides well-run courts with credibility and respect.
Self-empowerment by virtue of the Constitution of the United States that our founding fathers clearly articulated in the Constitution, the proper separation of the powers, which does not allow for the judiciary to perform the functions that are supposed to be performed by the other portions of the government. And that the 10th Amendment of the Constitution says that no state shall engage in conduct legislatively or judiciary in its composition or on an executive basis that would abridge any of the founding principles of the Constitution of the United States, especially as they relate to the Bill of Rights.
Okay, so basically you were asking for information on the GAL program and the AMC program, guardian ad litem and attorney for the minor child, and also about the rule changes, including probate judges, installation of special probate judges now in divorce cases, and so many other rules that extended their powers. What is the proof that those powers those are actually the powers that are being extended, or that's the rightful duty of the courts to create these programs?
Well, the general statutes in the state of Connecticut were amended in 1957, and those general statutes allow for the courts to have to follow certain procedures to preserve the independence of the functions of the judiciary and the legislature in this state. And our research says that we believe that the process that's supposed to be followed by our government in the conduct of their supervision of the changes of the rules of practice have been completely and utterly ignored by the members of the Judiciary Committee and the leadership of the legislature.
Now you've challenged the constitutionality to the Rules Committee directly at the judiciary. So isn't that really the legislative's job to challenge these?
That is exactly the point. The point is that if, in fact, there was going to be training by the GALs and the AMCs in this state, it would have to come as a result of a legislative action, not by passing a practice book rule. And that's what we're challenging. We're challenging what should be the independence of the judiciary and the functionality of these court appointees.
So that's what you're doing right now with all these papers.
So what we're doing is we put together the case to prove that the tenets of the general statute, 51-14, have been ignored in the process of self-empowerment. The requirements of the law in the state of Connecticut under 51-14 suggest that at the beginning of every legislative session that the Chief Justice of the Supreme Court is supposed to meet with the Speaker of the House and the President of the Senate in the state of Connecticut.
No, actually, she's supposed to send a report.
And to report the proposed set of rules
The changes, yes.
that are to be reviewed by the Judiciary Committee, who is has the responsibility of then conducting public hearings by law to review the proposed changes to allow the public to have input into this process, but also for the Judiciary Committee to judge the constitutionality of these proposed rules within the strictures of the Connecticut General Statute, which specifically says that the rules of practice shall not be used to amend, enlarge, or modify any substantive right or the jurisdiction of the court.
I'd like to thank this committee and the hearing for updates and revisions. I see many of these revisions are due to many parents' phone calls, letters, and testimony for so many clear constitutional, parental, and deprivation of civil rights under 42-USC 1983 Act. This commission must know that no matter how many updates or revisions a judge or a GAL would disregard the professional code of conduct or section 2-5A states good character and fitness to practice law will and does on a daily basis violate parental rights.
First, I'd like to object to the Family Commission having placed an amendment to the subject matter of revisions for consideration of the Rules Committee without due process for that submittal. And I'm going to let Mr. Nowacki, who's present here, talk more about that. There's not enough time for me. He's been versed on it. Concerning the new section 25-5A, automatic orders upon service of petition for child support. After the sentence, an automatic order shall not apply if there is prior contrary order of the judicial authority. I would add the automatic order shall be based on present salary status, listed on financial statements in the existing and realistic earnings of each party, and not on earning capacity. To offset what's going on in the judiciary.
Well, I think it's very important for the future of the state of Connecticut. I think the children in Connecticut are being cheated of the love of both parents. They're being cheated of their educational funding, and they're being robbed of formative years that could be happy, and they're spent witnessing their parents' self-destruction in the court system.
And it's also economic destruction as well?
Oh, beyond a doubt. It's designed, the system's designed to take money and destroy families.
I want to tell the audience I now requested the Judiciary Committee to show us the report that Chief Justice Chase Rogers submitted to the legislature, and quite frankly, I'm not so sure there is one.
Still, and video photography have long been among the best tools for capturing and conveying the news, and they have become increasingly important for an ever-growing proportion of the public as the news media become more digital. The pilot program that led to this rule included careful evaluation and feedback from all the key participants in the pilot process. We believe the proposed rule expands public access while maintaining courtroom decorum.
In this court's decision that they can make better decisions on what the best interest is. If we look at federal rules, I believe in federal rules, there be over 7,000 best interest standards. Our state has quite a few, but we all leave it to the judicial authority. There is no judicial authority. My authority as a fit parent is to make that decision, not to the judicial authority, to tell me who my son must associate with, who can intervene in my life, who can turn around and maybe in 5 years from now will be who play with my child in the schoolyard, because that's where this country is needed to, or this state. One thing right now that's pretty amazing to me is in Troxel versus Granville in Washington State. Washington still, after 10 years of ruling, found that the legislators cannot put a rule against a a parent's right to parent their child because it's a constitutional liberty. In this state, anyone can intervene. And at that, there's two different standards. We got some people saying there's a fair preponderance standard. We have some people saying clear and convincing. So far, there's one judge that just did dissent, and he does say that there is a clear and convincing standard you must get over, which in my case, the judge decided he wasn't going to apply it. How unconstitutional. He jumped right to fair preponderance of evidence. In my feeling, with everything from GALs down to court evaluations by court psychologists who clearly underneath the American Pediatrics guidelines to who is an expert is not qualified to talk about the disabled. These people work solely for the courts, as most insurance companies do not recognize your court psychology evaluations to be covered under insurance companies. We must, as parents, continue to pay out. Not only is it on this application fee, that application fee, this attorney, this guardian, on who? Guardians who are not licensed in Connecticut DCBAs have a behavioral analyst specialist, which that license does exist for autistic children to make a determination on what the best interest is. If we look at the IEDA law, again, federal educational law, we come together as a team for what is the best interest. It should not be one person's sole thought.
That no one is above the law while in family court. The family and I have heard lack of integrity by Judge Elliott Solomon, and sometimes I've had up to 26 people in his court when I was there for my children. And Judge Simone and Guardian ad litem Mary Bergamini, with comments quoted as, "This is my courtroom and I am God." As I talked for a full trial and was granted, one witness testified, 4 more waited, then the judge ended my trial, violating my due process rights for me to present evidence to save my son and daughter from our environment they were living in. Numerous police reports that the guardian ad litem never reported on what my children had to live through, and me as a dad that has been exiled because I exposed the GAL in court. Because of that, I started Save Our Kids PA Foundation in 2007. I speak here at the Capitol, the LOB in Washington, D.C. about these issues. I receive hundreds of phone calls every year, most concerns on GALs and their interference with good parent-child bonds. Most being alienated, and it's running rampant in courts like cancer.
I was turned down by that judge when I offered to go to the game at Yale University. Turned down by a judge, even when I said I would bring a police officer with me to the game if there was any concern about anyone's safety. Do you know that judge did not make that decision? This is the kind of conduct that goes on every single day in this court. And you, Your Honor, have seen 2 writs of mandamus from me as a Supreme Court Justice. One dealing with the unlawful stripping of my custody rights without a hearing. That was then reversed on March the 4th of this year. And do you know that while I was incarcerated unlawfully, I lost the custody of my children again? How dare you? How dare you?
I'm not sure with it. I personally would support it. I think it is the route we should go.
Further discussion? Second the motion. All in favor?
Aye.
Okay, we'll work on it this summer. I
Thank
appreciate
you.
it, Carl.
Thank you. Let's table to the fall.
Have we gotten
And we believe that the rules that were just passed this last week are clearly an abridgment of Connecticut General Statute 51-14.
Next person who has signed up is Cheryl Martell.
Good morning.
Good morning.
My name is Cheryl Martone and I'm from Westbrook, Connecticut, and I'm writing my book called CPS Crisis, How They Create Problems for Families. The reason being is that I receive many phone calls, emails, experience, and comments regarding these rules through Facebook, blogs, network boards, daily. Many of those were thrown into the courts by being falsely accused and wronged by false reports and false allegations by state agents. I reached out 3 years ago because I was falsely adjudicated by Middletown Juvenile Court, where they made a social study. I think that's mentioned in some of your rules here. Not afforded a fair hearing with my witnesses or evidence present and in violation of my due process. When I started to reach out to others because I could not believe what gross negligence has been done to my child, and I who was loving and innocent and never hurt anyone. In the juvenile, family, and probate courts, I find the same thing is being done to thousands of other innocent families in this state alone. I reach out to families like myself who have become distressed by the unconstitutional ways the courts handle your life case by allowing the state workers to make false reports, and I do talk about the social studies, narratives, etc., in the beginning, which is mostly false and fabricated. This is clearly violating our parental and 14th Amendment rights. I'm saying what you have or don't have for money, we shall be discriminated against in the courts, as this is about change as we bring it about in justice for our children, protect their relationships, their loving biological parents, that the courts try to destroy along with DCF, that they shall have a future with their biological parents, not the parents to become, not the cause of parents to become destitute. Secondly, the DCF, who call themselves social workers, do not have a degree in social work. They think they have the right to make mental health calls, when they are not qualified and are not trained to handle anything.
8-4, proposal by Michael Bowler on behalf of the Statewide Grievance Committee to extend the amendments proposed revision 1.15J3. Professional. Discussion?
Not substances.
And what we discovered was that before those rules could be published in the Connecticut Law Tribune, they should have been already subjected to the public hearings that are required by law in the state of Connecticut by the Judiciary Committee. Those hearings have not been being held, and instead the Judiciary Committee has been meeting in closed-door meetings with the Rules Committee and the justices of the Supreme Court to talk about the rubber stamping of these recommended rules, which then empowers the court without conducting the proper public hearings, and that the result of that means that the legislature and its Judiciary Committee has broken the tenets of the law in the state of Connecticut, which requires them to follow a certain process.
Second. All in favor? Aye. Opposed? That's approved.
Undermines the right for a party to contest a financial affidavit, barring the docketing and emergency hearing within 20 days 2025-5A motion or lack of during a 30-day pre-activation period. The 30 days would allow you to have the process of objecting to the contempt without having to be thrown in jail. And another thing is the state's very concerned about saving money right now, and they're trying to install some kind of rule. I don't think it's here, but they've already tested on Mr. Nowacki here, where he was in prison for 30 days under contempt, and they wouldn't conduct a proper habeas corpus for him, presented in court. They wanted to do it by video, and they cut him off. And they cut off his testimony. Click. May 31st.
You're right. At the Supreme Court, where a number of citizens stood up to speak about the abuse of process, which is what this represents.
And they just basically ignored, and they certainly ignored my comments of the like. After I testified, I said 5 minutes was not nearly enough to go through the problems that arise in these rules. And that could they please look at the written comments? But we have on camera that they didn't even look at the comments. They didn't even open them, and they rejected it on what?
Second. All in favor? Aye. Opposed? That's approved. All right, 8-10 were the comments. He had submitted, in addition to his written, his oral comments, written comments. Any comments, thoughts?
I love no action be taken. I don't think that there is anything here which is really appropriate.
Second. Discussion?
Yeah, I speak in support of that motion. And I say it in a way to address Mr. Knize. Many of the thoughts that were voiced by him are about violations of substantive law, constitutional law, as he understands it, and without wishing to take any objection to any of it, because of views he's entitled to have and a voice. It seems to me that this is not the role of this committee to pass substantive law. It's not the role of the committee to pass constitutional law, nor is it to establish substantive standards by which to evaluate particular requests. That is the limitation that's reflected in 5114, even though arguably 5114 is itself a purported limitation on the powers of this committee that exist under the Connecticut Constitution. But still, as to matters of public policy, that's ultimately the legislature to declare consistent with constitutional requirements. So many of the claims that are made, the concerns that are voiced about constitutional problems are certainly things that judges all have to take account of, whether or not the practice book references them. For us to try to concretize them in the form of specific rules is really not appropriate, not because of ignoring the Constitution, but because we understand that the Constitution is a supervening power that governs and guides us all, or must, and is thus available as an independent basis for legal action, irrespective of what the rules say. So, with respect to the positions taken, I don't believe that the rules is a proper repository for the views of this group or the rules of the judges as to what the Constitution provides. That comes in concrete cases in response to objections.
They rejected them on it being a constitutional issue and it's not their jurisdiction. Is that correct?
Well, that was what was said in the meeting. The question about whether or not it was within their authority as members of the Rules Committee to have to deem these rules as being constitutional before they could be adopted. Your Honor, will these letters be posted in the minutes of the meeting in the future? Because
I'm sorry, I think the rules are that although we allow members of the public, there can be no comment. Thank you.
I believe that's at the discretion of the chair, Your Honor.
The chair is
Robert's Rules of Order.
The chair is going to continue with that procedure.
Let me make an observation. I think that the practice has been that where written submissions are made at the meeting, that they are published on the website as part of the overall record before the Rules Committee.
All in favor? Aye. Opposed? That's approved.
Your Honor, I'm going to just leave now, but in their letter is a letter that's going to every legislator tomorrow morning claiming that every one of these rules exceeds the authority of the Connecticut General Statutes to increase the authority of the judiciary in the state. It is unlawful to consider the passing of these rules. Outright illegal. The fact that these seminars were already conducted by Judge Linda Monroe in advance of their passing shows how egregious the conduct of the Chief Administrative Judge of Family Matters is in this state. These seminars were already conducted at Quinnipiac University before these rules were ever passed by this committee. That is called ex post facto legislation. You knew it. I wrote to you as the Supreme Court Justice in a writ of mandamus asking you to investigate this as unlawful conduct, unlawful fundraising by the judiciary that was conducted already, and we got you. And now we are going to sue you in the U.S. District Court. You have violated the state ethics laws in refusing to investigate this, and you, sir, were part of that process. You got that writ of mandamus on March 18th.
Good day, sir.
Have a good day. But read the letter, because it's going to the legislature tomorrow morning. Anybody that votes on one of these rules is committed an unlawful act. Have a good day. I just wanted to see you approve one of them.
I don't think there's any reason for it. I mean, it doesn't really matter, titles are titles.
I have a question too about this. This is actually reflective of one of the gentlemen.
But if the judge then has new rules that come into place that circumvent the original rulings of the court, and that there's new rules in place that permit that activity, the judges then go back on an ex post facto basis to apply those rules, and ex post facto legislation is basically
illegal by the Constitution of the United States.
Underneath Section 1, Article 10 of the United States Constitution.
Yes.
But the costs in the state of Connecticut of litigating these matters makes it cost prohibitive before you can go to the U.S. District Court with a ruling to go fight this unconstitutionality. Because what they do is they bankrupt you on your way there.
Exactly. Act like laws, don't they?
Well, they
contain
a lot of the words.
They can make you get a psychiatric evaluation. They can make you pay for more lawyers and special probate judges.
Right, and we're challenging this as income-based discrimination in the state because they only force these appointments on those people after looking at your financial affidavit, and then they make these appointments without any restrictions whatsoever as to what kind of impact those appointments have on our family life, our ability to provide for the education of our children.
How about get rid of the JAL system?
I think completely and utterly get rid of the guardian ad litem system and get rid of the concept of immunity. I think the legislature of this state must enact a new law where there is no immunity for guardian ad litems. I think if they are exposed to litigation and to successful lawsuits challenging their positions, it would make them accountable and make them honest.
The idea of immunity, it's absurd because there is corruption, without a doubt, and the children are harmed.
And that goes for judges too.
Without a doubt. The idea of the judicial discretion, I have a big problem with that. I think a lot of the mistakes in my case were made because of the ability of the judge to make rulings off the cuff and declare them to be the result of judicial discretion. In the family court, they have quite a big a range.
And the problem is that they're not following laws. They think their discretion overrules the law.
They're not even, they're violating statutes. State statutes.
That's what I said. It's
yeah,
a law.
absolutely.
I mean, is a statute a law? I think it's a law.
Yeah, it is. It
Okay.
is. Sometimes
Right,
I wonder, though, because they violate them so readily.
Okay.
Have we gotten Judge Monroe's input on whether the new decision on post-nuptial agreements and the blessing of them by the court is going to require any rule changes?
It's attached. Her comments are attached.
Well, I see, but she says, she just says that, that there's a recent decision and
I think the second paragraph of that public
Right. And that's your understanding, that's the only thing that we need to...
Perhaps we should take them one at a time. Judge Winslow's comments first address section 11(1)A. Judge Monroe didn't feel there was a need for the distinction. Any comments?
I think there's a concern that the switch, the generic introduction to that, some rules that now exist that do apply to both sections. A bit surprisingly, I would say, that they do. And I use the discovery rules as an example, particularly the expert disclosure rules. There might be some change effected downstream by that change up front of the rule, because in fact, the same rule like 13.4 do apply in both venues. This may turn out to be a good idea, but it seems to me it should be thought through so that if we're going to do this, it's done in a way that affects every rule that is touched by it. And it's just a little late in the day right now for this particular change to do it. I would table the suggestion, number one, as potentially a good idea, maybe in a broader context for the law.
Any other thoughts on 11?
I agree with that.
I would move to...
Second.
Further discussion? All in favor?
Right, but the best interest of the child is really for the parents in their separate capacities to maintain wealth.
That is,
So that they can put their children through college.
that is
this
correct.
kind of thing.
And
Isn't it true that judges are raiding trust funds meant for college
Well,
to pay lawyers?
we have evidence in a case that Judge Monroe, who is the Chief Administrative Judge in Family Law in the state of Connecticut, worked with attorney Tom Perino, who is one of the members of the Family Commission of this state, to actually change the wording in the practice book, which would allow the liquidation of a child's trust fund to pay for court-appointed psychologists, guardian ad litems, and other court appointees, which means that this...
They could change the wording from the original contract?
Well, they didn't change the wording. What they did is they prohibited the original contract from going into evidence in this case that Judge Monroe was, knowing that there was language in the trust that was set up by the grandparents that prohibited the use of the funds from the trust to pay any kind of legal fees. So what did the judge do? She didn't allow for the copy of the contract to be entered in as a full exhibit, wouldn't even allow it as an ID exhibit in this case. And what did they do? They then liquidated a portion of this to pay
the language.
The lawyer.
They
And in
changed
essence,
the
what they
language
did
of the contract,
is
right?
that they didn't change the language of the contract. They circumvented your rights of appeal by not having that contract entered as an exhibit, and that was done with the full intent of the judge and the lawyer involved. And in this case, they then went in and attempted to change the practice book rules that would give the judges the discretion to liquidate a child's trust
All
fund.
in favor? Aye. Opposed? That's approved.
Because what they do is they bankrupt you.
Monroe solicited funds from the Connecticut Bar Association members in regards to GAL
Title IV funding, 300,000
training.
suicides in the family.
And she's brought into any hearing that parents want her to come to, and it's the same old story that they still violate the parents' rights, the good parents' rights.
This is the most dirty methods to relieve an issue that they don't like.
That is correct.
They don't expect as much out of us. They expect us to have integrity and responsibility for our actions. But their actions are proving the opposite, that they're actually abusing the system to abuse constitutionality itself.
All the guardian ad litems I've had any contact with have had been extremely questionable at best.
But they're not.
I began to observe the abuse of the Freedom of Information Act as it relates to our ability to be able to capture these meetings on tape. And Judge Linda Monroe immediately moved a meeting that was scheduled for a conference room into a courtroom to claim judicial privilege to not allow us to tape a meeting where she asked my former divorce attorney, who sits on the Family Commission, Tom Perino, along with Judge John Boland, to draft legislation for the next meeting to submit to the legislature that would give the judges a right to take away your children without a hearing.
Unbelievable.
And this is the draft legislation that was submitted at the November 17th meeting that would be going to the legislature if we did not stand up and say, over my dead
To our
body.
legislatures, you want a hearing at the Judiciary Committee about this.
Oh, without a doubt.
Tell them.
I want a hearing about the subject of the GAL being appointed to family cases.
And you, Ed? You want a hearing?
I'd like
at the legislature?
I'd like a hearing in the legislature about the lack of impartiality, about the grave danger of immunity for guardians ad litem and for attorneys for the minor child in contested custody matters. And I would also like to see the legislature mandate that once a child reaches a certain age, for example, 13, that they automatically be granted the right to have a judicial interview, and that interview be videotaped, and that therefore a child's interests and their desires about with whom, in terms of with which parent they prefer to live with, are made known to the court in an irrevocable manner, and that all of this manipulation by guardians ad litem and attorneys for the minor child would therefore be eradicated. It would solve many of the problems.
Okay. And how much will the state save in dollars by getting rid of the GAL?
I don't think it's an issue about the state.
Yes, it is an issue in the state. There's only one issue in the state right now, and that's to cut money. So is this a way that the state can cut money? Because they sure ain't funding anything.
Oh, okay. With regard to
how can the state save money?
The state can save a lot of money with the videotaping of child interviews, because it eliminates the need for the Family Services Department for children over a certain age.
Have you any idea what the budget for the Family Services Department is?
No, I don't.
It must be in the countless millions.
It would also save a lot of money for the state's Department of Children and Families, the DCF, because the child would be making a videotape record about what has happened to them and what and how they wish to live, and with which parent they wish to live.
And this would speed it up and reduce the hearings, right?
It would eliminate all of the second guessing, all of the twisting and manipulation of a child's wishes, and the basic sale of children, which is now being conducted by numerous lawyers in this state in child custody and divorce matters.
Okay, Leslie, last word. What do you think about all what he
Well,
just said?
I know the state does interview in some occasions. The question is, what's done with those interviews? My son's interview was never viewed, never taken into account.
So you want legislation for what? That
It mandates they be shown to the court. And
I guess,
well,
what's the point of it if it's not going to be used? Why put
Right.
the child through that trauma?
Okay, and you wouldn't know what the budget for that for all these.
Oh no, I should
It
imagine.
must be. The state could probably save $1 billion in the course of a decade, don't you think?
Yes, yes.
Also, it would save the court system tremendous time in taking numerous statements from attorneys for the minor child and for numerous statements from the guardian ad litem.
What we're asking the legislature to do and the General Assembly to do is to carry out their solemn responsibility on behalf of the citizens of the state of Connecticut to basically pass a resolution before they exit this session. Because underneath the rules of practice, the rules that were adopted by the Rules Committee after the one public administrative hearing at the Supreme Court that was held, those rules can be promulgated and adopted by the Rules Committee within 60 days of May 31st, without having had the General Assembly review those rules to determine as to whether or not they in fact conform to the general statute.
8.7, request by Judge Monroe that the proposed revisions to 2531, 2532A, 2532B, 2534, 2560, and 2560A, if adopted, be made effective as soon as possible, which probably would be August 15th or September 1st, like Charlotte.
Yeah.
Printing and...
Yeah, we have a rule that says rules become effective 60 days after the promulgation. You could ask the judges to vote for an earlier effective date. And normally the rules are published in the Law Journal as adopted by the judges in October. I mean, there's so much legislation out there right now that will affect our rules. And but we don't anticipate normally what's going to happen. We'll check this summer and bring it up for the fall.
consensus? We should table it for the fall? Any other proposals? All right, we'll table it we'll get into the public comments. 812 were materials submitted by Mr. Nowacki.
No, 812 is Levine.
I'm sorry, I have 813.
Oh, okay, never mind.
No problem. Concerning various proposed revisions to the rules.
I do not see where this comes under our purview.
Discussion? All in favor? Aye. Opposed? No action will be taken. Next, 813, we have proposals.
These rules, we find that if contempt is concerning 25A, 25-5A, that there should be a 30-day period to a hearing. And that on B, section B, after the capitalization about being punished for contempt, I would add from the words that are there, you have a right to, and I would add an automatic stay pending hearing and hearing by judicial authority within a reasonable time. The court shall fully address the findings on the specific allegations of any constitutional infringements before contempt can be enforced, and any further appeal in any court shall cause the stay to continue. Concerning 25-32B, another new section, discovery special master. The judicial authority may appoint discovery special master to assist in the resolution of discovery disputes, and I would add only as a last resort after all conventional avenues of discovery under Chapter 13 have been exhausted and a hearing, if necessary, on non-compliance was scheduled. Concerning section 25-34, I have a citizen's objection. Too much power for a judge. There's due process violations. Separation of powers in 51-14 violations. The proposed amendment violates civil rights concerning the person, property, and papers. And also violates the state constitution. I'll let Mr. Nowacki also talk more about that. Later on, your sentence is oral argument and the presentation of testimony on motions made under Chapter 13R at the discretion of the judicial authority. This is not a direction we want to head in this state. In fact, we really need to keep to what's been, and I would add that testimony on motions made under Chapter 13 are pursuant the rules of evidence and actionable as a matter of law, and however, specifically excluding discovery of such sensitive personal nature as to place a party in disrepute within the community as obviously shown by the result of a mental evaluation without the exercise of a clear and convincing present danger standard. We must have that, otherwise judges will abuse this rule. I don't think that, I just object to the rule entirely. It's unconstitutional. Right? With that ring, signify my 5 minutes. I have so much more to talk about. Please do look at all of these recommendations I have made on being. I am a producer, a legal producer. I also have authored a number of articles concerning these hearings, concerning the FOI Commission, and I will continue to do so. I'm watching this whole process, and please take my submission seriously. in terms of input from citizens given me, and I place it here for you. So I thank you very
If you have
much.
copies with you, we welcome those to be presented.
Okay, I only delivered about 20% of what I wanted to say. So, thank you.
Is Androgenis, who is a former appellate court judge that now works for a very lucrative practice on her own, basically advising clients as a former chair and chief administrative judge of family matters in this state, who preceded Judge Monroe and Judge Dewey in the position as the chief administrative judge of family matters. She's now gone into private practice, making $700 an hour to advise people in family court matters, and goes in front of Judge Monroe to argue cases. This kind of return into a position of power and influence by an appellate court judge, we find to be a huge conflict of interest that is basically outlawed in the federal government by the federal lobbying law. It is an unconscionable act that the chief administrative judge of this state circumvented the rejection of the GAL and AMC training in this state that was voted down at the 18th Rules Committee meeting in 2010. It got voted down. What did she do? She didn't take no. She went out and then asked Quinnipiac University to donate facilities, private law firms, etc., to attorneys to make donations to fund the GAL and AMC training, and she conducted it anyway.
Tell me why the Ethics Committee, when you brought this to their attention, then dismissed the case.
They claimed that because it was being run by Child Protective Services, and that they considered this an event, even though that it was a proposed practice book rule that then was passed ex post facto underneath the Freedom of Information Act, a request for them to turn over the list of donors who contributed to this, who we believe violated.
Show us that paper now.
And they have refused to comply with the law. And Carolyn Signorelli, who is the attorney, chief legal counsel, yesterday received a fax from me that basically said that this is the last time that she has the ability to be able to, within 30 days, comply with the laws of the state of Connecticut, and that she did not respond to that communication yesterday, both the phone.
And we asked them, what do they think the jury's going to think when finally presented with this information?
Well, we already have on the website the attempts by the lawyer for the Family Commission to dismiss the allegations that the Family Commission is in fact within the jurisdiction, underneath the definitions under the law, that the Family Commission is a public, judiciary, administrative function of the court.
Now, let me, don't interrupt me so I can get the serious events correct, okay? Basically, then after the Ethics Commission, you went to the FOIA Commission and filed there. Had a hearing, we put that hearing on YouTube. The audience can preview all the issues that were brought up during that, but there has not been a ruling yet. The ruling's going to take could take up to 8 months.
Well, the ruling by law does not have to be made until 1 year before the 1 year anniversary date. The original letter that I filed on October the 6th to Judge Linda Monroe, but the FOI letter of the complaint of the refusal to comply with the FOI Act. These are not events. They were mandated seminars that you could not get a future appointment of the court in the event that you didn't comply. The thing of the money in and of itself is called a solicitation by the judiciary function of the court, and such solicitations violate the 2011 Code of Judicial Conduct that was adopted in the state of Connecticut and became effective on that day. The fact that Judge Monroe raised this money in advance of the adoption, potentially, has not been revealed to us as to when those checks were actually written. To have the judiciary raising money from private attorneys who benefit from those appointments and suggest that that does not compromise the integrity, the conflicts of interest that exist when those lawyers who made these contributions are then awarded these huge opportunities to make money. This Dr. Kenneth Robson is the court-appointed psychiatrist here. He's a child-related psychiatrist.
And he's real buddies with the judge.
He was one of the presenters, interestingly enough, at the GAL and the AMC training. And when he presented his curriculum vitae to the court just 2 weeks ago, he was questioned about why was the GAL and the AMC training not put on his resume. May have in fact paid a fee to present, to earn their access to.
That's what you're trying to find out.
That is correct. But in order to do that, I'm going to have to sue. This is the letter that updates the legislature on the subject of what happened between May 31, where the Speaker of the House, Christopher Donovan, was contacted on the day that the Rules Committee approved some of these rules, where I walked out, went home, and contacted the Speaker of the House to say that this conduct is unconstitutional.
Okay.
This is the letter that details over 27 complaints against Judge Linda Monroe in the abuse of her authority as the Chief Administrative Judge in the state of Connecticut, along with other judges. This is the letter that goes to Eric Holder, the U.S. Attorney General of the United States, asking them to conduct a criminal investigation and a grand jury to indict these people who have violated the constitutional rights of the parents of the state of Connecticut for years. This is the actual statute, 51-14, that is published online. This is the document from the separation of the powers of government that is posted on the Connecticut Judicial website. This is the December 20th minutes of the meeting that talk about the use of teleconferencing hearings in only criminal matters, to which I was subjected to 2 unlawful civil hearings on April 15th and May 10th, which were not approved for use by the Rules Committee. This is the list of the people who are currently serving on the Rules Committee. This is a copy of United States Code, Section 42, Site 1983, on the civil action for the deprivation of rights that we basically experience regularly. This was the press release that announced Judge Linda Monroe that says, "I hope I can help ensure that our decisions continue to encourage the public to have trust and confidence in our work." I think not. This was the first meeting of the work group of family rules. Then we have an email that came out in November of 2008, changing the name of that to the Family Commission, and then put into place new places. After a series of Judicial Review Council hearings, we contacted the Attorney General of this state. He agreed with our assessment that the judicial review process should be more open, but that's a legislative matter. We then contacted the legislature in regards to this, and we were completely and utterly ignored, including by Tony Boucher, which is an email that I have dated May 19th, in the assistant to Senator Andrew McDonald, Laura Stefan, who responded, because you can't get a senator to give you a direct response on anything. We then requested Attorney General Blumenthal to supply us with information about why did the state of Connecticut not get anything out of the UBS settlement for $785 million. This shows that the federal courts are basically taking down the subject of the use of foreign accounts that are being sequestered overseas in marital accounts. This is proof that my ex-wife had one of those accounts and getting a $132,100 distribution from something called the Swiss Bank Corporation that ceased to exist 8 years before.
That the court ignored and would not allow your evidence.
That is correct, and would not allow it to be a full exhibit. This is the Department of Revenue Services press release that said that the state of Connecticut had an amnesty. That I am not going to allow this. Judge Stanley Novak took that exhibit, entered into a sealed envelope, and Judge Linda Monroe said, "I have no responsibility whatsoever to look at anything you present to this court because I took away your rights of self-representation." That's what happened. This is the letter from the Senate Democrats, the attorney, Natalie Wagner, basically saying that the members of the Judiciary Committee don't have to respond to the Freedom of Information Act as it relates to what did they do with all this judicial corruption and the request for a public hearing that they didn't say. This is an email from Judge Linda Monroe between meetings during the summertime where she approves changes in the language of the rules without a meeting, submitted by none other than Tom Perino, my former divorce attorney. This is the October 6th meeting of the Family Commission and the minutes to that meeting where they started to introduce the subject of the legislation that Judge Monroe requested Attorney Tom Perino and Judge John Boland to draft to submit to the legislature and to get that into her hands by the next meeting. This is the internal communication that happened minutes after I sent an email to Attorney Tom Perino after that meeting, charging him with treason for helping a judge to write legislation clandestinely. It violates the Constitution of the United States. Within minutes, it's sent to Judge Monroe. A conference call one day later with Tom Perino resulted in another email, redacted here, is Judge Monroe tells Tom Perino, please call me on my cell phone number, and gives him his cell phone number. And this is an open and fair process? We think not. This was the email sent October the 27th, seeking Tom Perino to resign from the Family Commission, or that I was going to sue him in the U.S. District Court for violation of our constitutional rights. This was the actual draft of the document, and the reference to that is in the November 17th meeting of the Family Commission. This is a communication from the Appellate Rules Committee that involves a Supreme Court Justice. And this is a document that was sent to Attorney Melissa Farley where she scrubs the date of the original communication when she forwards that. She removed it because the fact that she was already in non-compliance with the Freedom of Information Act complied within 30 days to fulfill the request to give those documents underneath the FOI law. They ultimately complied February the 28th.
So they tampered with the evidence.
That is correct.
And obstructed justice.
Right. And interestingly enough, none of these communications with any of these committees that have been sent to them directly, because the legal counsel and the chair of the committee has attempted to restrict the access of this citizen to the minds of the people that sit on these commissions, and I refuse to comply with that request. But none of the minutes to these meetings contain any of those letters,
right,
which they should.
Right.
This was when we went, the first communication with the Department of Justice on January the 11th that resulted in Attorney David Shelton being appointed to this case 8 days later. This was testimony by Judge Linda Monroe on the subject of whether or not our children should have the legal right to meet with a judge behind closed doors, to let them know what they want in a custody relationship that was objected to by Judge Monroe. She gives written testimony on pending legislation. We believe this violates the Code of Judicial Conduct in this state.
I agree with you that that process was perhaps illegal for that particular issue about the child expressing what he or she wants. But then again, a lot of people do want a proper procedure where a child can get on the stand and say what he or she wants, let's say past the age of 10.
Right, and this was my response to the chair, Senator Anthony Musto, on the Select Committee of Children, responding to the letters that were sent by Judge Monroe, Attorney Dornfeld, who represents the Connecticut Bar Association on child-related matters, who opposed the legislation, and then another attorney whose name is Grossman, that works for NH Legal Services, whose partner, Constance Francis, sits on the Family Commission.
Total conflict of interest.
Conflict of interest.
Okay,
More.
so this is concrete evidence
This
of
is correct.
all of these things.
This is the letter from Carolyn Signorelli indicating the following. As all activities as far as creation and presentation of the training materials are pursuant to private donations of the Law School of Quinnipiac, its staff, attorneys, and presenters. They have refused to provide us with that list of people who paid money to have that access. We believe that violates the state ethics laws and the lobbying laws of this state.
And they say it's an event
That's correct.
And that's why they don't have to provide that information.
That is correct.
Even though they are supervising and sponsoring, not by the court themselves by money, but sponsoring by initiative.
That is correct.
All right? Sponsorship can be by financially or by initiative.
Right. We now have the communication following the public administrative hearing by the Freedom of Information Council, the public hearing on April 11th. We had a meeting with the Department of Justice on April the 12th, and this is the email on April 13th predicting my arrest, which occurred 3 hours after I sent this communication, that predicted that the retaliation against me would result in the attempts to personally incarcerate me in the Whiting Psychiatric Institute for the rest of my life.
Okay.
And the Department of Justice intervened in some manner to pull me into a safe place.
You don't know that.
The Attorney General, the Department of Homeland Security was tracking my whereabouts while I was in prison. They said they could not confirm or deny, but when I checked out of the Whiting Psychiatric Institute, the officer that checked me out told me, "You're already a legend in this place. You must have some friends in some very high places, because on April the 29th, you were scheduled to be transferred from the Osborne Correctional Facility to the Whiting Psychiatric Institute.
Committed.
And you were not coming out."
They were
told.
trying to commit you,
That is
set
correct.
you up, fix you up using their medical examiner that's obviously prejudiced and buddies with the judge to make a hokey charge against you that you are not mentally stable, that you're bipolar and all of these things.
Exactly.
Now, of course, I'm asking the audience, viewing Mr. Nowacki, does he seem like this kind of person? Just one's common sense.
I'm a very detailed oriented person, and that I'm interested in helping people in this state who do not have the resources to go defend themselves, and that the work that has been done by a group of parents in this state to get together to share our stories is what this is all about.
Right.
This is about how our children have been harmed, how our constitutional rights have been eviscerated by the courts, and how we are not going to tolerate it for another day. I'm delivering them to each legislative representative in the House and the Senate.
Okay, now who are you asking?
Seem to be too old. I called Michelle a little while ago to let her know that I was on the way over here to deliver one copy. And I called Carl Testo's office to let Carl know that I was delivering one copy for the entire Rules Committee. And it would be up to Michelle or whoever to determine as to whether or not is the office here going to make copies for the Rules Committee.
Is this the whole packet?
Yes, that's the whole packet that goes to. So the question here is for Michelle, because I only brought one copy, because we're in the process of delivering this communication. Our next stop, I just talked to the Chief Legal Counsel of the General Assembly, because we have contested that all of the rules that were passed on May 31 were completely unlawful underneath the Connecticut General Statute 51-14.
Can I just show this to her?
Yeah, I left her a message on the car ride up to say I was coming up.
Anything you want to add?
No, I mean, Michelle is the chief clerk for the appellate and the Supreme Court, and she is responsible for the communications with the Supreme Court justices and the appellate court judges. She also sits as a member of the Advisory Committee on Appellate Rules. So she's been involved in my complaints that were issued at the last appellate court appellate court rules meeting, that they were engaging in conduct that was unlawful under Connecticut General Statute 51-14 in regards to some of these automatic orders that were attempted to be moved forward. And that...
It's a strange situation when you have a clerk as one of the parties.
That is correct.
And then she's got a...
and she has been noticed.
So basically she hasn't been calling you back, right?
That is correct. And that she has been engaging in conduct that is considered to be knowingly and willfully unlawful by the judges, because she's afraid, in my opinion, of the implications if she makes a point to the judges to say that this violates the Connecticut General Statutes. So the court operates on a system of fear that no one wants to do anything but to respond in a positive way to whatever a judge asks them to do. So we're here to deliver the documents to Michelle that is going across the street to the legislature momentarily, because Michelle controls the communications directly with the members of the Supreme Court, which would include Judge Dennis Everly, who was the chair as of the 1st of January of the Rules Committee of the state, and chaired the meeting last Tuesday, where a series of rules, which we believe are to be completely and utterly unlawful, were promulgated by the appellate, by the Rules Committee of the state.
Yeah. And what's key here is that you've done due diligence to notice them, and they still ignore you.
That is correct. And that I was not the only person.
Today, with these actions today, you expect more action from the.
Well, we just got off the phone with the senior legal counsel for the General Assembly, who's awaiting our next delivery at the Legislative Office Building to review these documents that we're basically giving to every member of the legislature, because in the past, the chairman of the Rules Committee or the legal counsel for each of the 3 administrative committees have attempted to block direct communications from the public to the members of the Rules Committee, the Family Commission, and the Advisory Committee for Appellate Rules. And that we're tired of having our voices stifled by the political processes of the judiciary system, because your case might in fact be heard.
Okay, so what would you like to say to citizens watching this video, how they can help?
Well, what we're hoping for is that between today and tomorrow that there will be legislative action taken by the passing of a resolution that will in fact repeal all of the rules that were passed by the Rules Committee unlawfully, we believe, on May 31st. And that we were challenging those rules, and we're asking for the General Assembly, before they finish their session, which they claimed last night they worked till 12:30 at night, on issues that are in front of the House that they're trying to basically pass legislation on. And we believe this should be a priority for them to pass a resolution that gets published in the Connecticut Law Tribune that would in fact repeal these practice book rules that were unlawfully approved last Tuesday. And if they do so, it will be the first step in the process of relooking at all of the rules that we believe have been unlawfully passed over the last few years in the manner in which they've gone about it, which has not failed, which basically has failed to follow the procedures set forth by Connecticut General Statute 51-40.
And the problem is that the Rules Committee passed the rules, and they're implementable and within 60 days, and yet legislature has set up the meetings about these rules a month after session and after that. So the present year session would never hear what was, as a whole, hear what the Legislative Committee and the Judiciary Committee did concerning these rules in time. So basically you have the implementation of the rules in 60 days and yet no public discourse, correct?
That would be the net effect of the procedures that appear to be in place by holding a Judiciary Committee meeting out of season to approve rules that have basically been promulgated by the Rules Committee itself, and that the General Assembly should be getting a view of these rules.
You're requesting to ask the legislature right now.
What we're asking the legislature to do is to pass a resolution to basically repeal the rules that were just passed on May 31st, that they not be able to be promulgated, that the Judiciary Committee must hold public hearings in advance of that to determine the constitutionality, which we believe that all of these rules that were passed do not meet the litmus test, that would require actually a legislative act to pass this as a law, but not as a rule of practice.
Right.
And that we believe that the law itself would be contradictory with the general statutes themselves that don't allow for the practice book to be used to abridge, amend any substantive right. And one of those rights is the subject of teleconferencing hearings.
Right.
That we don't believe that that's a right that the legislature or anyone can deny a citizen their rights to be brought to court as a self-represented party or as a defendant.
It's the most essential fundamental right given to American citizens.
Except in the state of corrupting it.
Okay. All right. So.
Goodness. Of the materials that deal with the judicial corruption scandals.
Okay. All right. Do you need to talk to anybody else?
Well, we spoke on the way up here to Susan, who is the chief. If we do not stand up for our rights and our freedoms to keep our government out of our personal lives, we will suffer the consequences for the rest of our lives. The purpose of the exercise of taking this to the legislature is to determine whether or not the 65% of our legislators who are lawyers, married to judges, or have a direct relative who's employed in the judiciary system will in fact stand up to protect the rights of the citizens and the children who are being affected by this corruption in the family court system.